arbitration बहुत लंबा जाए। कितना इसका वैल्यूएशन अच्छा लगता just single catch. Then 30. Then what and after this? Then after the second.
On the main list, item number 1.
Yes, the matter was learned the judge has allowed family pension, my lord, after a delay of 65 years, my lord. My lord, I have spoken to the department, my lord. This, my lord, only aspect that this should not be taken as a precedent, my lord, for other cases to come up, and this can be upheld on extreme compassionate ground, my lord.
Very, very, very gracious of your client. The matter pertains to the claim made by the widow of an erstwhile constable,
Lance Naik,
an erstwhile Lance Naik in the Assam Rifles. Full stop. Just give us the dates. The concerned paragraph. The concerned employee retired from service.
Was discharged from service.
Was discharged from service
on 15/5/1951.
On May 15, 1951, and died
Right, 2011.
In the year 2010, my lord.
And died in the year 2010. Full stop. When did she apply?
My lord, before he died, he applied. Before he died, and subsequently.
But did the man get regular pension till his death?
No, my lord.
It is an undisputed position that the concerned employee did not seek or obtain a regular pension till the time of his death. Full stop. It is possible that there was no provision for pension at the time of his discharge, and such provision was subsequently introduced, semicolon. But the fact remains that no claim was made by the concerned employee in such regard. Full stop. Paragraph. It was only in the year 2016 that the respondent herein applied to Assam Rifles for family pension. Full stop. Following the rejection of the claim on the ground that it had been belatedly made and that the concerned employee had not sought pension during his lifetime, the respondent carried a petition to this court under Article 226 of the Constitution. Full stop. The petition has been partly allowed by a judgment and order of September 19, 2022. Full stop. The writ court was of the view that the respondent herein, from a period 3 years prior to the date of presentation of the petition, 2016, and not for any period prior to that. Full stop. Paragraph. The appeal has been carried by Assam Rifles primarily on the ground that in view of the complete waiver on the part of the concerned employee to claim, the wife, the widow could not have resurrected the claim after nearly 60 years and 6 years after the death of her husband. Full stop. The paragraph. When the appeal was received, this court was binded to request Assam Rifles to consider the issue so that the legal issue, to consider the matter so that the legal issue raised would not have to be considered. Full stop. After all, the concerned employee may have been entitled to regular pension for a long period of time and and the widow would also be entitled to family pension upon the death of her husband, semicolon, but the writ court had provided for family pension to the widow only from the year 2016. Full stop. Paragraph. Since the matter has been resolved between the parties and Assam Rifles has agreed to provide to provide family pension to the respondent voluntarily, the order impugned will not be regarded as a precedent. Full stop. It is hoped that the money already due to the respondent on account of family pension would be released to her within 4 months from date, and that the monthly payments from June 2023 onwards will be paid on regular monthly basis. Full stop. Paragraph WA so and so of 2020.
65 days, my lord. There was a
Right
delay.
at the top, in view of the good ground shown, the marginal delay of about 65 days in preferring the appeal is condoned, and the appeal is taken up for immediate consideration. Fair well.
Item number 2.
My Lord, conducting senior counsel, Mr.
Sorry.
My Lord, conducting senior counsel, Mr. Amjad Ahmed, my Lord, he is suffering from...
What is the matter about? What is the matter about?
My Lord, this is an appeal, my Lord, against...
Very well. Where is the respondent?
Well, I am appealing for the respondent.
Yes. What is the matter, Dr. Saraf?
Well, this was some penalty was imposed for the short lifting of the coal, whereas below under the terms and condition, the power was only for compensation, and the said coal was sold to some other parties, and there was no loss to Coal India.
Very well. You're for the appellant.
My Lord, my Lord, senior counsel, Mr. Amjad Ahmed, my Lord, he is appearing in this case, my Lord. He is suffering from fever, my Lord. So
Very well.
Well, there is some delay in the filing of the
Condonation application.
My Lord.
Very well. Since the applicant seeks an accommodation, let the matter appear next week.
Well, I think the
My Lord,
delay may
after
be
2 weeks, my Lord.
Sorry?
Well, the delay may be delay is there. So the delay is
We condone the delay and take up the matter in the same breath.
My Lord, if it can be fixed after 2 weeks, my Lord. He is not well,
Fortnight.
my Lord. Obliged.
in both the cases, below.
We don't disregard, we disregard delay altogether. It's better to deal with matters on merits rather than technicalities.
My Lord, next matter
But
is same.
the delay is only contended when the case is weak. So I don't
Yes.
think that the delay should be a ground for.
Next one, same order.
Same order. Obliged.
I am obliged, my lord.
Item number 4.
Lordship, this matter has reached a final stage of the hearing, but it could not be taken up because of one of the member who contested the assembly election. Now is elevated as a minister. 3 fortnight. Oh, another 3 months, Your Lordship.
3 months. 12 weeks. It is submitted on behalf of the District Council that the committee that will hear the parties and take a decision in the matter is ripe to be constituted, and some time should be afforded for a decision to be reached. Full stop. Paragraph. Let the matter appear 8 weeks hence.
My Chopal. What number?
He's from Korea. Oh, God, Sarah. Family concern. Sir, today hopefully this matter should be over.
Either you take,
No, every day it will be changed. Every day in which direction he will go now. If you are prepared for A,
yes, you will come to me.
tomorrow also
Last time it was stuck down on quantification.
NTPC, I don't know in which direction you will go to. You work hard, you burn midnight oil, and suddenly tomorrow morning you come with something. This is like a seesaw. Seesaw. You are swinging like we are swinging like a pendulum.
He tries to go deep into
Very deep.
the quotations was not in my mind.
I was, it was, that's why I couldn't point. I argued this point that the Patel, he did not accept that argument because I said that it's a possible view and he dismissed my 37.
He doesn't bother about
He did not accept my plea in that I argued that point. Here now he's saying use of material.
possible view in that earlier petition.
Any mention for unlisted matter? Any mention for unlisted matter? From supplementary list, item number 1.
May it please you.
Yes.
The sought issue, my lord, after my argument, my lord, is whether in my bid did we submit before the authority that we will be importing the pen stop steel liner from outside India, my lord. Now, my lord, I have we did mention in the bid, my lord, and it was accepted and it is part of the contract. I will show those pages, my lord. This is one part of the matter, my lord. Second is that this project was also declared mega project.
You said it was not?
My lord, I will show from the documents also, and this project was declared mega project.
No, on facts, you cannot be.
Yes, your
There
lordship.
cannot be any dispute. He clearly said it was not declared a mega
Your
project.
lordship, even in the arbiter award, it is recorded as mega project. I went through the SOD 2-3 times to see whether there is any objection saying that it is not a mega project. According to me, I couldn't find it, but my learned friend did raise this objection here that it is not a mega project. But before arbitrator, it is not there. In the award, it is mentioned it is a mega project. I have document to show that it is a mega project, and their letter also shows that it is a mega project, and the very same letter of 21st April 2004, my lord, is signed by both parties, and it is part of the contract also, my lord. I have that contractual document also, my lord. If I may pass, my lord. And based on that mega project,
What are those? Have you given him?
this is contract, my lord. If your lordship will see the first page, the book 1, my lord.
Just. Yes.
Formal agreements, my lord, book 1, page 1, formal agreements.
Detailed work order and all correspondence.
Yes, your lordship. I am highly obliged, my lord. And then your lordship will see page 45, first page 45, my lord. This is later dated 6 February. 2004, my lord. And this is the letter, my lord, by which, my lord, if your lordship will see second paragraph, that Kameng HE project is yet to be certified by Government of India as a mega project. However, in the event of such a certification, the following benefits would be applicable, my lord. And then your lordship will kindly see the last. Accordingly, you are advised to quote the CIF component of your bid, if any, separately, my lord. And this is signed by both the parties, my lord. In the bottom, this is part of the contract also, my lord. And then your lordship will see there was a record of discussion between parties with regard to pricing, which is also part of the contract, my lord, at page 55. Because this is a JV with the Ukrainian company, my lord.
What is a JV with the Ukrainian company?
Ukraine, because the JV...
What is a JV with the Ukrainian company?
JV, this...
You are a JV.
I am a JV, my lord.
You are a JV.
JV. And this is the international competitive bidding, my lord. Page 55. Your lord, this record of discussion is also of 12th August, is part of the agreement signed by both the parties, my lord. Kindly see work program and last 3 line, my lord, of work program. Clarified that main role of JV partners have been procurement of steel and review of pen stock design in addition to other necessary technical advice. And then, my lord, at page 56, next page, there was a price discount, my lord, because pen stock steel liner were not being produced in India at that point of time also, my lord.
Where is that?
Yes, my lord. Reacting to the price and rates, my lord, we'll see this. Reacting to this, second line, Messrs. OMEIL stated that it is not possible in view of the sharp hike in the steel prices in international market. So, because they wanted the reduction in the bid price. However, the NEPCO insisted they agreed to rebid. So, international steel prices, parties were conscious of that fact that it is the pen stock steel liners are not produced in India. Steel prices are going to be.
Where do you find that? Pen stock not produced in India?
Page 144, my lord. Page 144 is again the commitment by JV, my lord. My JV part. 144. This is also part of the agreement, my lord.
144.
144. I'm sorry, my lord.
Yes.
And your lordship will see fabrication and delivery, and thereafter 1.1.6, and then thereafter JV's name is there, can supply 10,000 metric of steel plates of CIF Indian port basis. On metals, carries out delivery of steel plates and port of construction site, my lord. And then your lordship will see my alternate bid at page 170, signed by both the parties. It is part of agreement, my lord.
120.
170, 170.
117.
170, my lord. 170.
170.
And then this is my, your lordship will see the
This is
reference.
the same document which is
Same
there in
document,
the-
and is signed by both the parties and lord. And parties have acted on this. If your lordship will see in the bottom, both the parties, because I have shown, my lord, at the beginning itself that these correspondences are part of the contract. And now kindly see the work order at page 8.
Why are there 2 letters?
By mistake, I saw
a
that.
copy.
Too. Yes, copy, my lord.
No, this is not a copy.
It's probably marked to. I also noticed there were 2 copies.
There are 2 different letters. One has 1, 2, 3, 4.
Yes, my lord.
One has 1, 2.
Yes.
Anyway, yes.
Yes, your lordship. Kindly see.
And why have you flagged 116?
116 for the purpose of showing, my lord, that in the contract itself we have said that we will be importing steel from India and from abroad, my lord.
The plates will be procured from reputed Indian and foreign companies.
This depending upon availability
Availability and size and
and
quantity,
quantity, my lord. And they have never disputed this fact that this kind of steel was not manufactured in India. It was the manufacturing of this kind of steel started only in 2016.
All this has no reference in the award.
Milord, this has a reference. If I show that part.
In the award?
Yes, Milord, I will show that part also. But before that, Milord, page 8, Milord.
8.
8, Milord. This is a work order.
8 of this.
This page volume, Milord. Page 8, the work order. This is the work order, Milord. At serial number, your Lordship will notice, at serial number 7, 8, at page 8, whole good except to the extent of following modification, we shall supersede the corresponding NIT conditions, record notes of discussion, etc., wherever are variants, Milord. So these documents signed by parties, Milord, and then your Lordship will see the mega power project status given by the Government of India and forwarded by NEPCO to me. And this.
Why did you say, Mr. Jindal, then it wasn't a mega power project?
Lordship, here the original price bid, that is the quotations, were submitted on 2nd February 2004 and these were opened on 30th 4 2004 and that original price bid did not contain any foreign components, and this original bids.
And in the reverse, Milord, the certificate is on the back side, Milord. And what Mr. Jindal is saying is, again, with respect, is wrong, Milord. If I can show their own letter, Milord, these two letters where they gave the project authority certificate for import of the steel liners, Milord. Now, your Lordship, kindly see page. This is the project authority certificate issued by them, Milord. And kindly see page 2. This has a reference to project authority certificate dated so and so. Lordship may omit this part. And then last 3 lines of first paragraph. Value of so and so, 100 rupees. Quantity of 17th 12/2004 and contract, and your Lordship will see the same. It is certified that supplies, second part, contract agreement dated so and so are to be made in India to a power project and is under the procedure of international competitive bidding in accordance with provision of paragraph 82G and 844 of foreign trade policy, and stated by the contractor that import content of the order is approximately to the tune of 75 crore rupees and 12 crore rupees towards the foreign component, Milord. And this is in line with the letter of my page 170 at 21st April, Milord. Same component, Milord. And this has been reflected in the award also, Milord. If I can place that award also, Milord. If your Lordship will see my submission which has been recorded,
where is the award?
The award starts from page, Milord. The relevant page is, Milord, at page 70, 80, Milord. Kindly see. Page 92, your Lordship.
In 92, we have 5.32.
Yes, Milord.
But which part do you want us to see?
I want to show, Milord, page 82, paragraph 4.19 first, Milord. .13, page 82, Milord.
There is no 4.19.
Sorry, 4.13, Milord. Handwriting is so bad. Relating to claim number 2,
Claim number 2 has been allowed.
Yes, my lord. And relating to claim number 2, the learned counsel for the claimant in the rejoinder argument has contended that it is not correct to say that claimant in the statement of claim did not plead that delay cause is attributable to the respondent. The learned counsel also submits respondent nowhere has controverted the pleading of the claimant about date of issuance of project authority certificate for the availing the benefit of custom duty under mega power project status. And Kamang Hydro, and also date of actual procurement of component from abroad, apart from conversion rate as well as quantum loss suffered by the pleaded by claimant. Now, my lord, see the finding at page 90, my lord, 5.27. And at page 90, last 5 lines, the respondent in the written statement filed did not dispute the contention of the claimant relating to the date of issuance of project authority certificate, date of procurement of material from abroad, rate of foreign exchange, expenditure incurred by the claimant in procuring the material which are to be procured from abroad, as well as the amount of loss claimed to have been suffered by the claimant, contention of the claimant, and in that regard therefore remain unrebutted. I can show from the SOD also.
Your award says unrebutted.
Yes, my lord.
Uncontroverted. Uncontroverted.
I'm sorry, remain uncontroverted. Uncontroverted. I'm sorry.
Yes.
Sometimes I am too much uncontroverted, my lord. To say that it's not a mega power.
Show us Annexure 13.
Yes, my lord. Now, Annexure 13, my friend has placed only one page, my lord. There are other parts also. But your lordship may issue Annexure 13 for sake of my argument, my lord. In absence of Annexure 13 also, my lord, I have placed Annexure 15 and Annexure 16. Receipt of those documents have been admitted. Even in the SOD.
Let us see 13.
Yes, my lord.
Is it 295?
Yes, my lord, at 410, my lord. Because at the fag end, my friend has.
$410.
No, this is my very.
You had reduced it.
Yes, my lord, because why I reduce it, my lord? Because during the contract period, my lord, during the contract period, I made a claim, so the original contract period, so that I was not entitled to, so therefore I reduce it.
So you reduced it, it became 874.
Yes, my lord.
And original claim was what?
Original claim was, my lord, if your lordship will see, 10, it was more than 10, it is there in the SO. 352, my statement of claim starts, my lord. It's there in the award also. Yes, it is nothing in the award.
Where is your revised thing?
My lord, it is referred to in the award also.
I know it's referred to in the award, but where do we get the figure of 874?
Yes, my lord, that I will. 355 is, my lord, the SOC start. 352, amended SOC after revision, my lord. And
352.
yes, my lord. And page 4. And that exact page, my lord, is of 400 is amended, my lord, page 400. 404. 401 at the top, my lord.
$742.
Yes, my lord. And plus hydraulic cylinder, my lord. 1,31,80,000, my lord.
So that becomes 874.
Yes, my lord. And my lord, along with this, my lord, if your lordship will see the reply of the...
Have you been awarded interest?
No, my lord, no interest. Claim 1 is rejected.
Only this amount.
This amount, my lord. And post-award interest.
Post-award interest, of course. At what rate?
Post-award interest is, my lord, 93.
Very well.
9%.
9%. 9% is reasonable.
So, in my humble submission, my lord, parties have...
Very good. Yes.
Lordship, the contractor had submitted the bid on 2/2/2004.
It was supposed to be 51 months from the date of work order.
Yes, ma'am. 2/3/2009, my lord.
June 2009.
Yes, my lord. 2nd March 2009. 2/3/2009, my lord.
Date of completion.
To date of completion.
Yes, Mr. Jindal.
Yes, Lordship. The quotations with regard to the work in question were submitted on 2/2/2004. And these are the original quotation, if I am allowed to pass on. These quotations were opened on 30th/4/2004. And in this quotation, your lordship will find there is no requirement of any foreign exchange for any of the BOQ item mentioned in this. Now, based upon these quotations, we have issued him LOI. If your lordship come to page 193.
Yes. 3rd of December.
This is LOI, letter dated 3/12/2004.
3rd of December. Yes.
At Roman serial number 2, we refer to the offer dated 2nd February 2004. So LOI for the work in question was issued with reference to the quotations dated 2nd February 2004. On last occasion, your lordship, I have also pointed out certain data sheets which also bear the date 2nd February. If your lordship, I may take to page 181, 182 and 183, lordship will find where price variation components are given. It is dated 2/2/2004 and 183 is also 2/2004, and next page is also 223, and 185 is also 2/2004. Now, after this LOI, we have issued him the work order. Your Lordship will come to the work order at page 195. And your Lordship will see column 16. Column 16, your offer submitted under reference number so and so, 2nd February 2004. Even the issuance of work order was with reference to the initial quotation which he had submitted, and where the contractor has not mentioned any requirement of the foreign exchange. So he has a edge over the other bidder, because some of the bidders might have quoted the requirement of the foreign exchange. Since he has not quoted any requirement of the foreign exchange in its original bid, he was declared to be number one. And accordingly, the work order was issued. On this date, your Lordship, that is the date on which we have opened the tenders, and the date on which we have issued the LOI, and the date on which we have issued the work order, the project in question was never a mega project, your Lordship. It was initially only a normal project, and quotations which were given for the project not being the mega project were accepted where there is no requirement. After the letter which he has given 2000, after 2 or 3 years, as I understand now, that this project was might be declared as mega project, but quotation remains the same. There was no change in the contract agreement, your Lordship. Now, learned arbitrator, your Lordship, while awarding, has taken into consideration the letter by which the alternate bids were submitted. If I may take to your Lordship to the award, your Lordship, you come to page 74, paragraph 3.2, though it relates to claim number 1, but I wanted to point out the bids relating to claim number 1, which arose on account of deduction of 1% of the amount towards building and other construction worker welfare cess by the respondent from the RA bill of the claimant. It is pleaded that since the said cess was not applicable in the state of Arunachal Pradesh 28 days prior to the date of submission of bids, that is 2/2004. This also refers, your Lordship, to the bid dated 2/2004.
Advertisement.
Now, your Lordship will come to paragraph 4.6 at page 78. the learned counsel in support of the aforesaid claim submits that there being no dispute that a few components of contract are to be imported from abroad, and the claimant by letter dated 21/4/2004 having declared that they would be importing various components valued of rupees 75 crore and rupees 1200 crores. Learned arbitrator, your lordship, was referring to a letter which relates to the alternate bid. Then, your lordship, I once again, your lordship, draw the attention at page 92, paragraph 5.32. From the above discussion, it is therefore evident that the claimant was responsible, that the claimant was not responsible for delay in completion of the project beyond the stipulated time, that is 2/3/2009, and such delay was attributable to the respondent. Your lordship, I have already submitted. Since it is a finding of facts, I have possibly no scope to argue it on. Then, your lordship, as regards quantification, if your lordship come to paragraph 5.33, as discussed above, the claimant in Exhibit C30 has stated the loss incurred due to foreign exchange variation while procuring the imported steel liner plates, giving the statement regarding phase-wise procurement of steel plate liner by the claimant with respect to the PAC issued by the respondent, and also while procuring hydraulic cylinder from abroad. The respondent, as noted above, has not challenged the same at all. The claimant, however, by amendment has reduced its claim from rupees so and so to rupees 8.74 crores towards principal amount. Your lordship, the arbitrator says that we have not disputed Exhibit C13, and I have shown on other occasion also that we have in fact disputed this exhibit. The respondent claims that in view of clause 74 of the condition of, we took a plea under clause 74, that plea, your lordship, was rejected. Clause 74 deals with the price adjustment, price variation, which applies if there is a variation of the price of material except for those materials supplied by the corporation, as well as if there is increase or decrease in the local currency, cost of labor, and in the high-speed diesel. That said clause does not apply when the contractor suffer loss due to the foreign exchange variations. Your lordship, I have also shown on the last occasion, I took to your lordship clause 74. Clause 74, your lordship, not only applies during the contract period, it also applies in the extended contract period. That's, your lordship, I just will take 1 minute to point out that clause, which says that this price variation clause your lordship, may I take to your lordship at page 290. At serial number B, this clause shall be applicable only for the work that is carried out within the contract period or any extended period attributable to the corporations. Delay, your lordship, is found to be attributable to me. So this clause applies, your lordship, and he has been paid escalations, and that clause 74, I have also pointed out to your lordship that it includes within its purview the increase or decrease in the local currency. If US dollar goes high, there will be decrease in the INR. There will be decrease in the corresponding decrease in the INR. And if euro goes down, then INR will go up. So this increase or decrease in the foreign currency is also within the purview of Clause 74 under the heading it is covered. And I have filed an additional affidavit with the permission of this Honorable Court, wherein I have pointed out how much has been paid to the contractor under this Clause 74 on account of.
Thank you.
Only 1 point, only 2 minutes, Your Lordship, with kind permission.
You are paying, sir. You can take 2 hours. You'll be heavily penalized for running a completely dishonest case.
Lordships. Only, Your Lordship, I just wanted to point out that at 5.35, Your Lordship will find here that in view of the aforesaid discussion, the claim is entitled to an award for rupees so and so for the loss. Here, Your Lordship, there seems to be no application of mine, and how and on what basis he has arrived this calculation, Your Lordship.
Thank you.
I highly advise.
It is a matter of shame that government bodies tend to challenge arbitral awards irresponsibly, and the court is attempted to be misled in the appellate stage on matters as to fact. Full stop. Paragraph. The challenge here, in proceedings under section 37 of the Arbitration and Conciliation Act 1996, is to the dismissal of a petition questioning the propriety of an arbitral award dated
is 27 April 2017, Miller.
April 27, 2017. Full stop. It is evident from the award that of the two claims, only the second claim on account of foreign exchange variation has been allowed. Full stop. The fundamental premise of the challenge to the award is that the contractor quoted the price of material in Indian rupees and nothing in the price bid of February 2, 2004 indicated any foreign exchange component thereof. Full stop. In short, the suggestion by the appellant is that since prices had been quoted in Indian rupees, there could not have been any claim on account of increased price of the goods supplied as a consequence of the Indian rupee depreciating against the US dollar or the euro. Full stop. Paragraph. This fundamental premise is completely flawed and is belied by a certificate issued by the Government of India on May 15, 2006, which indicated that the coming hydroelectric project, bracket 600 MW, bracket closed, was declared as a mega project. Full stop. Indeed, the arbitrator proceeded on the basis that it was a mega project. Full stop. The certification of the work as a mega project entailed that no import duty was to be paid on the CIF component, CIF capital, of the goods to be supplied. Full stop. Implicit in this was the recognition that goods had to be imported for the purpose and supplied for the project. Full stop. Paragraph. That is not the only aberration or the false hook on which the appellant hangs its case. Full stop. There is more. Paragraph. On April 21, 2004, the contractor addressed 2 letters to the appellant employer furnishing its alternate price bid. Full stop. These letters were issued in response to letters written by the employer requiring an alternate price bid to be submitted in the event the project was certified as a mega project. Full stop. The clear indication in both the letters dated April 21, 2004 was that steel of various grades of value of rupees 75 crore amount to 2,105,000 equivalent to rupees 12 crore as on the relevant date. Full stop. There is no dispute of the receipt of such letter. Full stop. Indeed, comma, as noticed above, the Government of India certified the power project to be a mega project in May 2006. Full stop. Paragraph. In dealing with the claim on account of the foreign exchange variation, comma, the arbitrator noticed the pleadings of the parties and the submission put forth, full stop. In such context, comma, paragraph 4.5 of the award is relevant, full stop. Such paragraph records the submission on behalf of the claimant-contractor that it had incurred a loss in excess of rupees 7.42 crore because of the devaluation of the Indian rupee and the delay in the execution of the contract and finalization of design of penstock steel liners, which resulted in a rescheduled procurement of steel liner plates from abroad beyond the original contract period. Full stop. The further submission on behalf of the contractor was that hydraulic cylinders had to be imported and the falling rupee resulted in increase in the cost of hydraulic cylinders in excess of rupees 1.31 crore. Full stop. Paragraph. The award then proceeds to notice that in the letter of April 21, 2004, the contractor had expressly indicated that they would be importing steel components of value of rupees 75 crore and another set of components of value of rupees 12 crore. Full stop. The arbitrator was satisfied that the two components referred to in the letter of April 21, 2004 were steel plate liners and hydraulic cylinders. Full stop. Paragraph. On the merits of the claim, comma, the arbitrator noticed on the arbitrator held at paragraph 5.32 of the award, that the claimant was not responsible for the delay in completion of the project beyond the stipulated time, and that the delay beyond March 2, 2009, open quote, was attributable to the respondent, bracket in italics, the appellant herein, bracket closed, full stop, close quote, full stop. The arbitrator then went on to discuss the claim on account of increased cost of the two components, dash, steel plates and hydraulic cylinders, dash, and notice that the original claim put forth on such count of rupees 9.13 crore was reduced to rupees 8.74 crore. Full stop. This reduction was due to some of the components having been procured and supplied during the original tenure of the contract by March 2, 2009, for which the contract disentitled the contractor to claim any additional amount. Full stop. As for the procurement of the rest of the two components, the balance quantities of the two components beyond the contemplated period of the contract, the arbitrator did not find any embargo in the contract to disentitle the contractor from seeking such amount. Full stop. Paragraph. It may do well, in this context, to notice the following lines from paragraph 5.27 of the award, next line, open quote, 5.27, ... Then start. The respondent, bracket to bracket italics, the appellant herein, at the same time in paragraph P capital 12 has contended that delay was caused due to magnitude of work, completion of which depends upon various factors, such as political, natural, geographical, etc., and hence putting the blame, according to the respondent, on it alone for such delay is apparently vindictive in nature and not in keeping with the spirit of the contract. Full stop. The respondent in the written statement filed did not dispute the contention of the claimant relating to the dates of issuance of from abroad, the rate of foreign exchange, the expenditure incurred by the claimant in procuring the materials, which are to be procured from abroad, as well as the amount of loss claimed to have been suffered by the claimant. Full stop. The contention of the claimant in that regard, therefore, remained uncontroverted. Full stop. Now please underline from did not dispute the contention up to the end. Up to the end, and then after uncontroverted, full stop, close inverted commas, then italics, E capital, emphasis supplied, bracket closed, bracket to bracket, italics, full stop. Paragraph. What is undeniable is that upon going through the records, the arbitrator came to a conclusion that certain goods were to be supplied by the contractor upon procuring the same from abroad, and that even though the contract prohibited additional amounts being sought on any count whatsoever, if the supply was made during the contract period, comma, if the supply was made beyond the originally contracted period, comma, the embargo on the price would no longer operate. Full stop. The arbitrator was satisfied that there was a foreign component which was involved, and that for the foreign component part, and that the parties were aware of the same, comma, inter alia, comma, as evident from the letter dated April 21, 2004, issued by the contractor to the appellant herein. Full stop. The appellant has referred to several clauses of the contract, including clause 74 pertaining to price adjustment stroke variation. Full stop. There are three parts to paragraph 74, colon. The first pertaining to price variation on account of labor, comma, the second pertaining to material, and the third pertaining to high-speed diesel. Full stop. In respect of both high-speed diesel, in respect of both material and high-speed diesel, comma, there is a formula which is indicated, and any price variation, comma, whether to the benefit of the contractor or to the detriment of the employer, would be compensated by adding a further component to what the contractor is to get, or deducting a component from the contractually agreed price. Full stop. However, comma, the entirety of clause 74 is governed by the general conditions indicated at the end, comma, including the stipulation that the clause, open quote, shall be applicable only for the work that is carried out within the contract period or any extended period attributable to the corporation only. Full stop. Paragraph. According to the appellant herein, clauses 75 and 76 pertaining to currency restrictions and rates of exchange were apparently struck out from the contract as being irrelevant, full stop. It is also a position accepted by the arbitrator as evident from the award, full stop. There is also no dispute that the agreement envisaged, that the contract envisaged that the work would be completed within 51 months of the date of the work order, and there is no dispute that such time ran out on March 2, 2009, full stop, paragraph. Thus, on the basis of the material available before the arbitrator, particularly, and the correspondence exchanged by the parties which were expressly included, which were expressly incorporated as part of the contract, there were certain foreign components that were to be procured from the Indo-Ukrainian JV contractor, joint venture contractor, semicolon, that a substantial part of such procurement was after the contract period was over, semicolon. As a result of this delay and the Indian currency falling against both the US dollar and the euro, there was considerable increase in the procurement price from abroad, semicolon, and the delay in this case of the work within the stipulated time was solely attributable to the employer, full stop. In the paragraph, in view of such findings, particularly the one rendered on facts, that the delay was solely attributable to the employer, the arbitrator found the claim on account of additional expenses, paragraph. There is a slight murmur on the part of the appellant that the arbitrator apparently accepted the claim on account of foreign exchange variation without applying his independent mind to the matter, full stop. It may do well, in this context, to refer to the quoted paragraph from the award and the recording therein that the employer in this case chose not to deal with the calculations furnished by the contractor for the increased expenses incurred due to foreign exchange variation, full stop. Once a claim is put forth, it is for the other party to deal with the same, full stop. In the present case, the employer denied the basis for the claim and but failed to deny the quantum or the components going into the quantum of the claim, full stop. As a consequence, once the arbitrator found that the basis of the claim was justified, the arbitrator was not required to apply his mind to the quantum of the claim in the absence of any denial in such regard or dispute being raised. Full stop. The only situation where the arbitrator could have looked into the quantum was if it appeared to be palpably absurd or patently erroneous. Full stop. Since the total value of the foreign components had already been indicated to be to the tune of rupees 87 crore as at the time of furnishing the bid or as at April 21, 2004, the notorious fact that the Indian currency devalued was taken into consideration by the arbitrator to find that a reduced claim of about 8.74 crore due to the foreign exchange variation was not absurd or outlandish. Full stop. Paragraph. In view of the frivolous nature of objection to the award fashioned by the appellant in course of the appeal, the respondent was constrained to rely on the original agreement and several correspondence exchanged between the parties, which were all incorporated as part of the agreement, full stop. Ordinarily, in proceedings under section 34 of the Act of 1996 or in the rarefied atmosphere under section 37, when considering the dismissal to a challenge, the court is not required to look into the primary documents or even the agreement between the parties, full stop. If a plausible view appears to have been taken from the face of the award, the court does not dig much deeper to seek any justification therefore. Full stop. Much of the time in this case was wasted upon the appellant's assertion that there was no foreign exchange component involved, since the price bid was made in Indian currency and the contract did not envisage procurement of any component from outside the country. Full stop. Paragraph. Whether for the fear of vigilance or for other more disagreeable reasons, comma, government bodies are disinclined in accepting awards or acting in accordance therewith. Full stop. Facile challenges are launched, comma, sometimes based on untenable or tenuous grounds or on erroneous facts, as in the present case. Full stop. Much of court time and the tedium involved in sifting the truth from the rest in such matters can be avoided if government departments took a bit more responsibility in such regard. Paragraph. There is no basis to the challenge to the arbitral award. Full stop. The court of the first instance acted in accordance with the letter and spirit of Section 34 of the Act to find no fault with the award. Full stop. At the end of the day, comma, it must be kept in mind that the court does not sit in appeal over an award, but the court is required to interfere only when it sees manifest injustice or something which would not pass muster under the public policy or the basic tenets of justice as followed in this country. Full stop. Paragraph. For the appellant's efforts, comma, the appellant will pay a sum of rupees 3 lakh by way of costs in addition to the award and the post-award interest awarded thereunder. Full stop. In addition to the principal sum awarded and the post-award interest. Full stop. Arbitration appeal number 1 of 2022 is dismissed as aforesaid. Costs are always payable to that in a commercial matter. Why should we gain from the costs?
From the main list, item 1.
Lordship, I'm seeing if this matter can be taken up next week, Lordship. The arguing counsel.
Well, since this is an appeal, appellant seeks an adjournment, let the matter appear of fortnightance. Yes.
Item number 2.
Lordship, item number 2 is a contempt petition.
Yes. Where are the contempt notes?
Lordship, by the last one.
Lordship.
You represent the contempt notes?
Yes, Lordship.
All of them?
Today morning, Lordship, we have filed the power, Lordship, in respect of contempt number 1, Lordship. And in respect of contempt number 2, Lordship, we are filing it in the course of the day.
And you represent all the contempt notes?
Lordship.
There are 2 or 3?
2, Lordship.
2. Very well. What is your name?
S. Chanda, Lordship. S. Chanda.
Mr. S. Chanda appears for both the alleged contempt notes. Full stop. The the paragraph, the alleged contemnors will deal with, will file an affidavit to the contempt petition within a fortnight from date. The matter will appear 3 weeks hence.
Hello.
Yes.
Item number 3.
AMPT.
Yes, my lord. May I please, your lordships?
The road, Paikan Road is much improved now.
Yes, my lord.
Paikan Road is much improved.
Yes.
Then the road from Rongram going into Dadingre, not Rongram, I think that road going to Dadingre
Yes.
is a beautiful road.
Yes, my lord.
And much of the road towards Fulbari has also been repaired, but not all of it.
Yes.
Not all of it.
No, I'm very much thankful for interference of the Honorable Court. Before it required 5 hours to reach the Gwalpara. Now hardly 2 hours is required.
Yes, and once it's completed,
Yes.
there will be tremendous improvement in roads all over.
Yes, my lord.
Hopefully, they will last the rains which have just started, but there has been remarkable improvement.
Only, my lord, only I am not dissatisfied on the 32 to 41, my lord. That one is still up and down. Blacktop it seems that they are only painting the road, my lord. And it is going to be eroded. Now going to be finished, I think within this, it will be completed.
Just look into it. We'll just require the PWD to look into it.
I was
Yes, my
personally
lord, only
there.
for
I had
observation.
randomly dug the
Yes,
road.
but between 32 to 41.
We have a report also.
Very
It is
well.
as
We'll
per the
record his
specification.
submission and there has been considerable progress in the repair and construction of the AMPT road, and some stretches have been completed. Full stop. Even the petitioner acknowledges the same paragraph. However, the petitioner apprehends that the contractor may be using pastel colors for blacktopping the stretch between 32 kilometers and 41 kilometers instead of heavy duty bitumen. Full stop. The paragraph, it is, however, submitted on behalf of the state that the PWD has kept a close watch and is monitoring the work particularly on such stretch, full stop. Paragraph, to the extent that the petitioner's grievance amounts to the level not being ideal on the relevant stretch, the relevant officials from the PWD in the area should take care of the same. Full stop. We'll dispose of the matter.
Yes, my lord.
Let's keep it one more time and then we'll
Yes,
dispose
ma'am.
of the matter. Let the matter appear 6 weeks hence in the hope that the stretch complained of and the rest of the road would have been substantially completed by then. How much more work is left, sir?
Lordship, 32 to 41, as my friend had complained, is already complete, and it is as per the specification. I was personally there, Lordship. Now, only what remains is, this is 67 to 100 kilometer, where the work order has already been given, and the time period is 24 months. Lordship.
24 months.
Well, Lordship.
Paragraph, it is submitted on behalf of the state that work order has already been issued for the 67 to 100 kilometer stretch, and the time allowed for completion is 24 months. Full stop. Thus, full stop. Paragraph, thus, the rest of the work should be in place by the time the matter appears next.
Deployment.
Just look at it. Ask them to look at it. He's saying something.
this
Why
portion,
should he?
my
Has
lord,
not made
otherwise
any
it is okay.
needless grievance. He has not made any needless grievance, and after all, because of him and your active cooperation, those people are getting a better road.
Lordship, yes.
We are grateful to both of you.
Grateful.
Much appreciated.
Yes.
Deployment.
Item number 4.
Well, this is an appeal for conviction under 302. But I was praying if this matter gets taken up after 2 weeks, my lord. Well, it'll take a little while to.
We are not trigger happy. We let you go if you are entitled to. Why do you want more adjournment? Since the appellant seeks an accommodation, let the matter appear a fortnight hence. Do your matters. After 2 weeks, both the matters are coming.
Both the matters I'll do, my lord.
Please do.
My lord, I will.
Yes.
Item 5.
Lordship, this is a criminal appeal actually. This is a paperwork is to be prepared, but for some.
Paperwork is not ready yet?
Not ready, Your Lordship. Actually, for some financial constraint, it could not.
Last time also it said paperwork not ready. Why?
Yes, Your Lordship. Appellant's wife has come actually only in the last week. So 3 more weeks actually, it will take.
The paperwork should be made ready within the next 3 weeks. No further accommodation will be granted. Paragraph, the matter will appear 4 weeks hence.
I look.